Mr. Sharkey, you're still under oath and continue with your investigation.
Thank you, Your Honor. Okay, Agent Shock, let's talk about 1960 Hawaii, the presidential election related to that. Let's hopefully we can get through this pretty quick. You're aware that the Republican Richard Nixon was initially declared the winner of the 1960 Electoral College votes from Hawaii?
Yes.
And you're aware that Democratic candidate John Kennedy challenged that, correct?
Yes.
Eventually, President Kennedy was awarded the 1960 Electoral College votes from Hawaii, right?
Yes.
And are you aware that the governor of Hawaii originally sent a certificate of ascertainment in favor of Mr. Nixon and consistent with the Republican certificate of votes?
Yes. Excuse me.
Very close to January 6th of 1961, the Hawaii governor sent a new certificate of ascertainment in favor of the Democratic certificate of votes. Are you aware of that?
Yes. Yes.
And fair that that new certificate of votes happened after the statutory date set for the electors to gather and cast their electoral votes. That year was December 19th, 1960. Are you aware of that?
I don't recall that part.
Okay.
I may have reviewed it, I just don't recall.
Okay. So, just to summarize, so we're all on the same page, there were two certificate of votes submitted on December 19th, 1960, right?
Yes.
A Republican slate, which would have been the official certificate of votes as of that date, right?
As of December 19th?
Correct.
Yes.
And a Democrat or alternate slate that was contingent, a contingent certificate of votes as of that date. Yes? Maybe that was an inartfully stated question.
Yeah, it was,
Sorry.
You got me.
Let's
confused.
look at it. May I approach, Your Honor?
Yeah.
I'm going to hand you what I'm marking as proposed defense exhibit E.
There is a D.
There is a D? E.
What did you say?
E. Do you recognize the document I just handed you?
Yes, I don't recognize the envelope, the copy of the envelope.
Okay, so there's 5 pages to the document I handed you, correct?
Yes.
The first 2 pages are the actual certificate of vote, the Democrat contingent certificate of vote, right?
Yes.
See where it says at the top,
Yeah.
Democratic
Yep.
electors?
Yep.
Okay. You see at the bottom it says persons voted for John F. Kennedy.
Yes.
All right. And that document is signed by 3 individuals and is dated, I know it's dated December 19th, 1960. And it's at the end of the end of the first paragraph on page 1. There.
Yes, it is. Yep.
Oh. Okay. Let's take a look at this document. So, again, this one, the vote as of this time, when this document is created, was in favor of Nixon, correct?
No, it was in favor of Kennedy.
The actual vote. So the vote count as of December 19th, 1960 was in favor of Richard Nixon.
Oh, yes. Yes, that.
So this document was signed, proposed defense exhibit E was signed by Democratic electors when their candidate had not won the election, fair?
Yes.
Okay. Let's look at the language. Do you see at the top in the first paragraph where it says that these 3 Democratic electors were, quote, duly and legally appointed and qualified.
Are we gonna move to admit this document before we publish it?
I would love to move to admit the document.
Any objection to the admission of the document?
No.
Document, Defense Exhibit E is admitted.
Would you like a copy, Your Honor?
Yes, please.
Do you see at the top of Defense Exhibit E, where it says that these 3 Democrat electors were, quote, duly and legally appointed and qualified by and for the state of Hawaii, as appears by the annexed list of electors made, certified, and delivered to us by the executive of the state? Do you see that?
Yes.
Were these 3 Democrat electors the duly and legally appointed and qualified electors for the state of Hawaii on December 19, 1960?
It appears so based on what you showed.
Okay. And as of December 19, 1960, would you agree that the executive of the state of Hawaii is the governor of the state of Hawaii?
Yes.
Did the governor of the state of Hawaii deliver to the Democrat electors on or before December 1960 a certificate of ascertainment declaring them to be the electors for the state of Hawaii?
I don't recall that. Is the certificate of ascertainment with this?
It's not.
Okay. I don't recall that, so is that, I don't recall
Okay.
if they did.
You don't recall that we just went through it before, and I know you said you didn't have the date, but that the governor of Hawaii issued a revised or new certificate of ascertainment in favor of John F. Kennedy on January 4th, 1961. Are you aware of that?
Yes.
Okay. So if that's true, the governor of Hawaii issued a certificate of ascertainment to the Republican electors in Hawaii before December 19th, 1960, right?
I don't recall the specific date, but yes, I know that they delivered the certificate of ascertainment.
Okay, and then it changed, because something happened after December 19, 1960, right?
Yes.
The election, it flipped in favor of President Kennedy, right?
Yes.
You're aware of that.
Yes.
And so a new certificate of ascertainment was provided by the governor of the state of Hawaii in favor of the Democratic electors, right?
Yes.
So my question is, on December 19, 1960, did these electors, these Democratic electors who signed Defense Exhibit E, have a certificate of ascertainment declaring them to be the duly appointed and qualified electors for the state of Hawaii?
Well, the certificate of ascertainment was provided by the governor.
After December 19, 1960.
Right. So what, I'm not clear about what you're referring to.
If the Democratic electors did not have a certificate of ascertainment from the governor of Hawaii on December 19, 1960, could they have been the duly and legally appointed and qualified electors as of that date?
No.
Did they file and sign a false document back in 1960?
No.
No,
They didn't, because it had the certificate of ascertainment.
they didn't. That's what I'm telling you. They only had a certificate of votes. The certificate
Are
of
you
vote.
telling him or you asking?
Right.
Did they only have the certificate of votes as of that date?
I don't know because I don't have all the material here in front of me.
Well, we're gonna have to focus a little bit because you know the history. So we're gonna go through it real slow. All right? On December 19, 1960, right? Do you know the significance of that date?
I'm not familiar, well, yes, I do know the significance of the fact that they gathered and signed the document on that day.
That is the statutorily required date for electors for the President of the United States to vote pursuant to federal law and constitutional law. Are you aware of that?
For Hawaii or in general?
In general. And that can be different dates. So in 1960, it happened to be December 19th.
Understood.
In 2020, it was December 14th,
Okay,
because it's something like the third Wednesday after the second Monday, or whatever the language is, right?
yes, so that's where I was getting confused about what you're talking about.
Okay, so now let's focus. In 1960, December 19, 1960, that's the date that the electors had to vote, correct?
Yes,
Okay. On that date, President Nixon was ahead. He was the one who was declared the winner of the state of Hawaii as of December 19, 1960, correct?
yes,
The governor of Hawaii, prior to December 19th of 1960, issued a certificate of ascertainment naming the Republican electors for the state of Hawaii as the duly appointed electors for that state, correct?
yes.
Okay. Now, something happened after December 19th, 1960 that changed the results of the election. Are you aware of that?
It's my understanding the electors met together.
Okay,
The
hold on.
Republican and Democratic electors met together.
They did.
Okay, so
Well, then
they-
I'm asking
they-
about
I understand that you asked the question, so I'm trying to tell you what I know.
Yeah, but you're, well,
So,
that's
so
not
they
helpful.
met, so they met together.
Well, it's not helpful because you're not answering my question, so you can elaborate, but I didn't ask you who was
Counsel?
together. Well, what? Oh, sorry.
Yana, I would ask that the witness be allowed to answer the question, and I know it might not be helpful to Mr. Denini, but it's still an answer.
Well,
And I would ask that
You
he be
can't
allowed
stop
to
him from
complete his.
answering because his answer is not helpful. To the extent he's not answering your question, that's different.
Yes,
But if
that-
he's providing an answer and you don't like it, that's the risk you take when you ask the question.
no, and I, it's fair, and we can have the question right back if we need to, but I don't think I asked the question that elicited were they together
The question was, did something happen on or about December 19th?
after.
After December 19th.
Right. And that's got nothing to do with whether they were together on December 19th.
I agree.
So, after December 19th, 1960, we've already established the significance of that date, right?
Yes,
Okay. After that date, there was a recount, correct?
yes,
A circuit court judge in the state of Hawaii on December 14th, 1960, called for a recount. Were you aware of that?
yes.
It was on that day.
I'm aware of the recount. Thank you for providing the date.
All right. And after that date, the results changed so that actually John F. Kennedy won the state of Hawaii. Are you aware of that?
Yes,
And after that, because clearly that happened after December 19th, 1960, fair? The recount
the recount was before, right?
was after December 19th, 1960,
Was after December 19th.
correct?
Okay.
You aware of that?
Yes.
All right.
I'm just trying to keep
I
track
know.
of this conversation.
I know.
It's,
All right. And so if that happened after, the governor of the state of Hawaii is not going to issue the new certificate of ascertainment until he knows that votes flipped, right?
yes,
And on January 4th, 1961 is when the governor of the state of Hawaii issued a new certificate of ascertainment in favor of the Democratic slate of electors. Are you aware of that?
yes,
All right. So, my question is, if, now that we have established that on December 19, 1960, the Democratic electors did not have a certificate of ascertainment in their hands, in their possession, so were they the duly and legally appointed and qualified electors for the state of Michigan on December 19, 1960?
For the state of Michigan?
Sorry, for the state of Hawaii on December 19, 1960.
they didn't send the document in saying that they were.
Right.
That document didn't travel to DC prior to January 5th? No,
January 6th.
January 6th?
Of 1969. Okay, but I'm not asking you about that, so let's focus. The document itself, you got it right in front of you.
Yes,
Defense Exhibit E is the certificate of votes. That one happens to be the Democratic certificate of votes, which is a contingent or alternate slate. Would you agree with that, as of that time?
yes. At that time, yes, it was an alternate slate, but they weren't presenting themselves as an alternate slate. Or, I'm sorry, as the electors. They were presenting themselves, as my understanding, as the alternate slate.
Fair. But let's look at the face of the document, okay? I just read it, let's read it again. First paragraph. These three Democratic electors were, quote, duly and legally appointed and qualified by and for the state of Hawaii. Let's stop there.
Yes.
On December 19th, 1960, is that a true statement?
It's a true statement based on the information that you've provided. I mean, I wasn't back in 1960, so I'm basing that response on the document that you provided.
Basing what response? I don't think I've heard a response yet.
Yeah, I said it's a true statement.
It is a true statement.
Yes, I just said that.
Okay, so on the face of this document, Defense
Because that's what
Exhibit
it says.
Defense Exhibit E, it's your opinion that this is a true document as of the date it was signed, correct?
I don't know what a true document, what kind of true document it was at that time. What I do know is what I'm reading in front of me, which is presented to me now. What it was back at that time, I can't answer.
Well, you're gonna have to answer with all due respect. So let's focus. People's Exhibit 14 was essentially Chesbro, excuse me, I'm gonna check that. Ken Chesbro, when you interviewed him, told you he used the 1960 Hawaii precedent as an example when he drafted the 2020 alternate elector certificate of votes, didn't he?
That was part of it.
Okay. But he used that as an example, correct?
Yes.
All right. And would you agree with me that a lot of the language in People's Exhibit 14 mirrors, we'll look at them side by side, mirrors the language in this Defense Exhibit E?
A lot of the language, I would
Yeah.
say some of the language, yes, does mirror it.
Specifically the language that I'm quoting right now.
Yes,
Okay. And you have initiated charges, your affidavit has initiated charges in this case because the document, People's Exhibit 14, is allegedly false on its face. True?
yes,
The falsity is that you say that these individuals, Kathy Burden specifically, signed a false document, right?
yes,
The falsity is that the document declares her to be the duly appointed elector for the state of Michigan, correct?
yes.
So what I'm trying to get at with my questions about the 1960 Hawaii document is, why is it false in 2020, but it's true in 1960?
Again, the 2020 case, you know, as I put together my affidavit, was a culmination of facts and information. The 1960 case is different, like I said earlier, the fact that they met together. There was a recount initiated. I was not aware of any recount in 2020. I was not aware of any evidence to suggest that the Democrats, electors, and Republican candidate for electors met together to cast their votes for the person in their party.
Okay, well, people got along a little better in 1960 than 2020, so I'm not sure how relevant that is, but.
Move to strike.
My focus is on the language of the two documents, all right?
Okay.
Okay. The three Democratic electors from the state of Hawaii on December 19, 1960, said they were the duly appointed electors for the state of Hawaii, and they were not, as of that point. Were they?
Not at the time that this was signed.
Right, okay, all right, we're getting somewhere. So, was it false at the time they signed it?
Yes,
Would you have charged these three people back in 1960 for signing that document?
I didn't hear what you said, because you spoke at the same time.
I said, would you have charged?
Oh, she said something, I don't know if she was staying in the objection. I heard your
Oh,
question.
sorry.
I'm objecting for speculation and relevance.
I think it's very relevant, Your Honor. It is
So
speculation.
See what he would have done in 1960?
Yeah. If he's presented these facts as an investigator who's been assigned to investigate whether a crime has been committed, and he saw that somebody, for his testimony just now, signed a document and it was false at the time. It's the same document. So would he have charged them back then? I'm curious.
In the state of Michigan, obviously, because our laws are not the same as Hawaii's law.
And with all due respect, the facts as have been laid out repeatedly on this record are different.
Well, I
So-
think that if the court allows the question and he answers, he can obviously indicate that.
Yes, Your Honor.
By saying no, and then I'm sure there'll be a follow-up question, and then he'll explain why it's a no. But whether or not he would have charged these people in 1960, based on information stated today, I will allow him to answer that question. You have a specific question?
I want to know the answer to that
Oh,
question.
No, I don't have, I mean, all I have in front of me is a document. For me to speculate on whether or not I would charge, again, we talked about this, I don't charge, okay, I gather the facts, we talked about that. You've presented me with one document. For me to say that I would charge based on one document, no, I mean, in an investigation, we try to gather facts and information, evidence, interviews. And so that's the process that I would use. So to answer your question, again, no, I wouldn't, because I'm only looking at a document, trying to make a judgment call based on one single document, without one single interview, without one single search warrant, or any other physical evidence.
Okay. All right. Is it fair to say, now you said that the document they signed was not accurate at the time, so they signed a false document. Did I have that right? In
Who's
sorry,
they?
They, the Democrat electors on December 19th, 1960.
Yes,
Right?
yes.
Okay. And can you see that while they signed a document that was, at least in the four corners of the document, technically not accurate as of the time, can you see that there was a potential contingency that occurred that could then make that document be a valid document?
Yes.
And that's what happened in in January of 1961, right?
Yes.
So essentially, the Defense Exhibit E, which was not true as of that date, became true after the governor of the state of Hawaii issued his revised certificate of ascertainment, correct?
Yes.
All right. And then, just real quick, I read it, but do you see where it says, I was focused on the duly and legally appointed and qualified. At the end there it said, and delivered to us by the executive of the state. Do you see that?
What paragraph?
Sorry, it's in the first paragraph, I believe. Hold on. Yeah, it's in the middle there.
Yep, I see it.
Okay, and that too, as of December 19th, 1960, was not true, correct?
Yes.
But it became true on if we assume January 4th, 1961 is the date that the governor issued the new certificate of ascertainment, it became true later, correct?
Yes.
Is that kind of by definition what a contingent document is all about?
Yes.
Sir, would you agree with me that there are certain similarities between Defense Exhibit E and People's Exhibit 14?
Yes.
They both say duly elected and qualified electors. Would you like a copy of the People's Exhibit 14 to compare them side by side?
Yes.
Okay. What's that? Great. Thank you.
Please, thank you.
I'm handing the witness People's Exhibit 14 and just directing him to page 2 of that document.
Thank you.
Okay, do you see, both say, and again, let's try to go through this pretty quickly, but they both have the words duly elected and qualified electors for president, fair?
Yes.
And this document doesn't have anything about receiving anything from the governor or the executive of the state of Michigan, right? The People's Exhibit 14.
No.
All right, I'm gonna retrieve those from you.
Okay.
Yes. Okay, all right. Sir, you know from your investigation that Kathy Burden didn't orchestrate any of the events that occurred related to the alternate electors on December 14th, 2020, right?
Yes.
You know she just showed up that day per Stu Foster's request?
Yes, she did show up that day.
And if anybody was behind the scenes orchestrating things, it was people like Laura Cox and Stu Sandler on the MRP side, fair?
Yes.
And Sean Flynn and Mike Roman at the national level?
Yes.
And Mr. Flynn and Mr. Roman were acting at the direction of the Trump campaign?
Yes. And I believe there was more people involved, obviously.
Sure.
We're just not mentioning.
Sure, those are just a few of the people, right?
Yes.
And yet Kathy Burden faces 8 felonies in this case, and the people I just mentioned haven't been charged with a thing, right?
Yes.
Never interviewed Sean Flynn?
No.
Never interviewed Stu Sandler?
No.
Never interviewed Mike Roman?
No.
Isn't it true that you, in your affidavit, either ignored or left out some exculpatory evidence related to Kathy Burden?
No.
How about Defense Exhibit B? You know, remember that document that she signed on December 14, 2020?
Oh, yes, I'm familiar with it.
Go ahead, give it to you. There's a copy of it.
Thank you.
Sir, is Defense Exhibit B contained anywhere in the affidavit you presented to the magistrate judge seeking charges in this case?
No.
Why not?
This is a separate document. This document never made it to the National Archives. I found no evidence of that. It never made it to the US Senate. I found no evidence of that. And the document that I received in the course of my investigation was blank. So it didn't even have Kathy Burden's signature on it.
So, okay, I was wondering, because I didn't see the signed version in the discovery, so you didn't even have that?
No, I had the document.
The blank
The
document?
blank document. The blank document was provided to me by Troy Hudson's counsel, Eric Doster.
All right. The blank document?
Yes.
Okay, but not the signed document?
No.
Okay, you know that that exists now, though, right?
I'm looking at it right now, sir.
All right, well, we introduced it already in this case through
Yes.
other witnesses, right?
Yes, to answer your question, yes.
Okay. All right, and so you see that document in front of you, right?
Yes.
And you see that Ms. Burden signed it, correct?
Yes.
And we know she signed it on December 14, 2020, correct?
Yes.
And we know that because it was notarized, correct?
Yes.
And it was notarized by Henrietta Toe, correct?
Yes,
Henrietta Toe is an MRP employee, right?
yes,
She was present on December 14, 2020?
yes,
Would you agree with me that this notarized document, Defense Exhibit B, is very clearly, it has conditional language in it?
yes,
You see where it says the Republican alternate electors, quote, would cast their votes for Donald J. Trump?
yes,
Would you agree with me that notarized documents take on greater legal significance than those that are not?
I would say the notary adds proof that the signature was witnessed by somebody else.
So adds hallmarks of authenticity.
Yes,
Now, in fairness to Ms. Burton, don't you think when we're evaluating her specific intent, we ought to look at this document, Defense Exhibit B, at the same time as we're looking at other documents that you presented in your affidavit?
yes,
But you didn't give the magistrate judge that same opportunity, did you?
no, I didn't have it, the document with her signature on it, okay?
That's fair. So do you remember when you first saw the signed document?
It was, well, am I allowed to, you know, we had met in some sort of attorney proffer.
Me and you?
Yes,
Okay.
so am
I
I
gave
allowed,
it to you?
yeah, am I allowed to talk about that?
Oh. No, okay. That's fine.
Is that,
Sure.
okay. Yeah, so that was the first time that I saw it signed.
Well, I'm glad you got it as part of your investigation. So you got that after July of 23 when you filled out your affidavit, correct?
Yes,
After charges were filed, correct?
yes.
Does that document in any way change your opinion of Ms. Burton and her specific intent in this case?
No,
Doesn't.
no, there's two documents that were signed by Mrs. Burton.
Uh,
One document is intended just as what it says in here, and it says, they were available to meet and perform their duties as presidential electors. The other document did not say that, but both were signed by. Again, this document didn't go to the Senate in the National Archives. This document, I had no evidence to suggest that this document was attempted to be delivered to the Capitol, the state of Michigan Capitol at the time.
Right. So the Defense Exhibit B is not a certificate of vote, sir. Okay, certificate
Yes.
of votes get mailed to Washington DC pursuant to federal law, right?
Right, I understand that.
That's not what Defense Exhibit B is, so when you keep talking about the fact that it's not mailed, that's kind of besides the point, okay? We're trying to establish Kathy Burton's intent on December 14, 2020, between about noon and 1:15, fair?
Yes,
And Ms. Burton signed Defense Exhibit B between noon and 1:15 on December 14, 2020, correct?
yes, yes,
And so she signed a clearly contingent document at that time, right?
yes,
And then another document was placed in front of her, and her signature appears on the signature page, right, of People's Exhibit 14, right?
it appears on the signature page and the alternate elector pages as well. There's 3 pages it appears on.
When you say alternate elector pages, do you mean the replacement elector?
I'm sorry, the replacement electors, yes.
Okay, so let's focus, okay, we'll get to that if you want to. That's where Mr. Renner was one of the replacements,
Yes,
right? And I
yes.
forget who the other one was that goes off the top of my head. Doesn't matter.
Yeah,
Okay, so that's over here.
Thompson.
Thompson. All right, but, all right, let's do this. Where's, you got 14 still? Yep. Okay, we've heard a bunch of testimony, obviously, about this document. That, we don't really have conclusive information that page 2 and 3 of that document were presented at the same time to all 16 electors that were in the room at the MRP headquarters, do we?
Yes,
Didn't we hear testimony that that signature page was kind of sitting there standalone?
during the course of my investigation, I had mixed reports that the signature page was standalone, but also others reported that there were some other documents on the table along with it.
Right. So we really don't know if Kathy Burden signed the standalone signature page, which is also Defense Exhibit C, and whether she actually saw the page that comes before it in People's Exhibit 14, correct?
Yes.
And so, again, my question to you is, in fairness, in July of 2023, you had no knowledge of Defense Exhibit B, right?
Yes. Well, no, I had knowledge of the knowledge of the document. I had no knowledge that it was ever signed or anything like that.
It's fair distinguished, or a fair point. So, let me restate the question. In July 2023, when you submitted your affidavit in support of charges in this case,
Yes.
you were not aware that Kathy Burden signed in front of a notary Defense Exhibit B.
Yes.
Okay. And we've established that what's important for these charges is Ms. Burden's specific intent to defraud between noon and 1:15 on December 14, 2020, right?
Yes.
You now know that in that time period, she signed Defense Exhibit B, correct?
Yes.
And that document is clearly contingent in nature, right?
Yes.
My question to you is, does that change your opinion of Ms. Burden's specific intent?
Your Honor, I believe that's been asked and answered.
Please answer that question.
Yeah.
And may I have it again?
He said no, he gave the reasons why. he didn't.
Still no?
Yes. Still no. I stated.
This is staged.
Okay.
All right, you kind of focused on mailing of the documents to Washington DC, right?
I talked about them. Yes.
Okay. Now, while Ms. Burden's name is on the envelope, you know from your investigation that she did not mail those documents to Washington DC, right?
It doesn't appear.
You know Sean Flynn did.
Again, we've talked about that. I had information that Sean Flynn had talked to Kathy Burden. He, in an email, he sends an email to Mike Roman, John Black, and maybe a Terrell, stating that he had talked to Kathy, that asking if it was okay to use her address. I have Tony Zammit had indicated in his conversation with Sean Flynn that the next step was to mail the documents off. But I didn't have, I don't have, physical evidence to show who exactly was at that post office at that time. And we talked to the postal inspector about that.
Right, no, I know. I saw that in your affidavit at paragraph 25, where you talked about going to the post office and all that. So we know it was mailed from the East Lansing, Michigan Post Office on December 15, 2020, right?
Yes.
And do you know that that happened around the early afternoon, around 2 or 3 p.m.?
I would have to look at the notes.
All right. Now, I know the emails you're talking about where Sean Flynn tells Mike Roman and others that he talked to Kathy Burden, but you know he didn't talk to Kathy Burden, don't you? We went through that. Sean Flynn texted and connected with Stu Foster. He asked Stu Foster to reach out to Kathy Burden about her address and making sure that was correct. And then Stu Foster then communicated that to Sean Flynn. You know that, right?
Now that you're recalling it, I don't recall.
All right, let's
But
take-
as you're recalling it,
Do you recall it now?
I don't, if I could refer to my notes.
Well, I don't know what notes you'd refer to, but if you have notes that confirm that, sure, you can look at that.
Or at, part of the report I'm referring to.
I'm handing you a text string between Sean Flynn and Stu Foster.
So you had this at the attorney proffer. I
Yeah.
did not,
Go ahead, I'm sorry.
you provided this to us at the attorney proffer. I don't recall this being a part of my investigation. This document and your signed document by Kathy Burden here. You presented to us at the attorney proper. That was the first time that I saw it.
Okay.
So as you're refreshing my memory, yes, I remember you doing it.
Are these now part of your investigative file?
They're an exhibit, yes.
Do you dispute their authenticity?
No.
Is this in fact communications between Stu Foster and Sean Flynn on December 14, 2020 and December 15, 2020?
Well, I have a, what I'm looking at here is, and I haven't read all of it, but what I'm looking at here is a screenshot of a text message. I don't have anything to suggest, maybe I'm missing it, that says that it's from Stu Foster. So and typically, when we do an investigation, this would be a lead, and we try to verify that through search warrants and obtaining additional data or evidence to show that, yes, they communicated. So, I don't see Stu Foster's name on here, but,
Okay,
So-
did you collect Stu Foster's phone?
no, I did not.
No? Okay. Didn't think that was important?
We reviewed the phone, he allowed us to take screenshots of specific messages, and that was it.
Okay, and this is not one of the things he gave you, because I'm pretty sure this document we received through the AG discovery. You're not thinking?
I don't recall seeing this. I remember the first time that I saw this was when we were in the attorney proper and you presented.
All right. And so if this, and I think there's other, but if this evidence suggests that Sean Flynn sent a text message to Stu Foster on December 15, 2020 at 2:55 p.m. while he's at the East Lansing post office, wouldn't that be important information as to who mailed these documents to Washington, D.C.?
Yes.
That's assuming a lot of facts that
Well-
are not in evidence.
Well, but, go ahead.
Address the objection.
That there is evidence that very strongly suggests that what I state, all the facts that I just stated are accurate. This text has a priority mail, a picture of a priority mail, U.S. Postal Service sticker that very much matches the information that was on the actual envelope that gets sent from the East Lansing Post Office on December 15, 2020. So when Sean Flynn is communicating with Stu Foster and he sends a picture of the thing that shows up on the envelope, it is highly probable that that's where he was, and there's more information in the discovery. I don't have it right here, but we'll, if this case continues, we'll get it. But Sean Flynn's the guy that mailed these documents, and your investigation, certainly after I showed you this, should have shown that.
What facts are you objecting to, better than that?
I'm objecting to that the text message was sent from the East Lansing Post Office. We have yet to verify that this is a conversation between Stu Foster and Sean Flynn, and also hearsay.
How do we know that the text message was sent from the East Lansing Post Office?
Well, from other documents, but even within this, and I can ask the question, maybe this
Other
would-
documents that were in
just
that-
produced in discovery, not in the record yet. But I will ask a question, does I think somebody testified to, does the fact that the blue border behind the priority mail give you any indication that this is where that picture was taken? You see the blue behind the sticker?
Yeah.
Are you aware that the East Lansing Post Office has a blue counter?
No,
You're not aware of that?
no.
All right. But in context,
Well, we
just
still have to address the objection.
to address if this is between Stu Foster and Sean Flynn, I mean, in context, you read it, right? It says, it starts with, you gotta call Troy, that would be Troy Hudson.
You're not addressing the
Oh,
objection.
sorry, what's the objection? I'm sorry.
She said it assumed back that's not in evidence. One was whether or not, how do we know this was sent from the East Lansing post office? I don't think that we've been able to establish that in the, what's the other one spoken?
That this is a conversation between Stu Foster and Sean Flynn. The witness has said that he cannot identify that this is a conversation between those two.
He has stated that, and he said that if he had something else that could identify, or maybe it was in his notes, but that's not been identified. So,
That's fair.
the objection's sustained.
Thank you.
After you received this document I handed you, did you follow up on it?
You never gave it to us. You gave it to us at the proffer and then took it back. So I never had the ability to take a picture of it or anything like that. And it was my understanding that that conversation and this information was just to be kept between the attorneys. So you didn't leave me with any investigative leads to follow up on.
Certainly you were presented with information that suggested that Sean Flynn was the person who mailed these documents on December 15, 2020, correct?
I have information that suggests that he was involved in the mailing, yes.
But you haven't confirmed that yet.
No, and I did take that information, just looking at the snapshot, and again, focusing in on Mr. Chesbro's evidence, and paired them up, which is, okay, Mr. Chesbro presented an email that was similar in nature, so to your photo that you presented to us at the time.
You didn't go back to Stu Foster.
No, Stu Foster didn't want to talk to me. I think the second time I reached out to him, he made it clear he just didn't want to participate.
All right, but I mean, you've executed a ton of search warrants in this case, and if you felt that he had information that was relevant to your investigation in his phone, you could have very easily gotten it, right?
I wouldn't say very easily, no. I mean, there's a process in order to secure that.
Strike very easily. You could have gotten an image of his phone if you had wanted to.
Yes.
All right, let's talk about Mr. Chesbro. Okay, you are aware that he is an attorney, right?
Yes.
And he worked on this alternate elector plan as it occurred in Michigan and also the other 6 states, correct?
Yes.
And let's just be clear, the other 6 states are Arizona, Wisconsin, Pennsylvania, Nevada, New Mexico, and Georgia. Are you aware of that?
And Pennsylvania.
I said Pennsylvania, yes. All right. You interviewed him, Mr. Chesbro, on December 6th, is that right?
Yes.
Who else was present for the Chesbro interview?
His attorneys, AAG Van Langeveld and AAG Primo. And I think it was just the 2 attorneys, just his 2 attorneys.
Ms. Logan present, no?
I don't believe so.
Okay. And does he have any kind of deal or immunity? I think you said to Ms. Chartier that he was there pursuant to a proffer agreement, but I just want to make sure I understand.
A proper agreement. It was at that time. Where we're at with that, I don't.
Let me ask you bluntly, was he told he wouldn't be charged?
No, I don't recall us ever telling him that.
Okay. So
Meaning those seated at the table.
Okay, so to your knowledge, he doesn't have immunity
Not to my knowledge.
in Michigan? for these
No.
items? He told you he worked for the Al Gore in challenging the election results in Florida back during the 2000 presidential election?
Your Honor, I'd like to object, this is hearsay.
Well, I'm building up in terms of what is Mr. Chesbro's education, his history, how come Mr. Chesbro is involved in this, but kind of giving some background about what it is that this alternate elector concept came from, and it adds to the 1960 Hawaii, and the 2000 election, I believe, is something that the investigator would have considered, and so I'm trying to just get it into the conversation that he had with this witness.
You're gonna ask this witness about Mr. Chesbro's background and history?
Not much,
Oh,
more than
I
this.
thought that's what you were saying. But is it being offered for the truth of the matter asserted?
Well,
So
no,
hearsay objection.
yeah, no,
What
it's
is the
not.
purpose that it's being offered?
It's really that he considered it. I mean, did he consider it as part of his investigation? All right, let me ask this. Maybe we can start.
Charge withdrawn?
No, not withdrawn, but maybe I'm going to ask a quick question that maybe gets around it entirely.
Well, we can't skip over an objection and ask
Fair.
another question.
No, I don't. So I would say it's effect on him, but I think there's another potential either hearsay exception or non-hearsay point that I would like to raise with the court, but I need another question to that.
What would be your follow-up question for that purpose?
Is Mr. Chesbro an unindicted co-conspirator?
In our case?
Well, you don't have to answer that because we're addressing the objection.
Okay.
So understanding what his next question is.
Well, I don't think Mr. Chesbro's work on the Gore Bush campaign in 2000 has, well, first of all, there's been no foundation laying how this witness would know that other than if he got it from Mr. Chesbro himself, which would make it hearsay. And, even with the follow-up question, that still doesn't make the answer any less hearsay. The only point of the follow-up question, if Mr. Chesbro is an unindicted conspirator, would make openings for statements made in furtherance of the conspiracy. So anything happening in 2000 would not be in furtherance of the conspiracy that occurred in 2020.
First, the purpose that you were offering this was so that you can lay some foundation about the background. And I don't know if you've been established if he knows any of this information directly from Mr. Chesbro. So maybe we should go that route first. I am gonna sustain the objection the way the question was asked.
Okay. I really only have one question about the 2000 presidential election, which is, did he tell you he worked on the Al Gore campaign?
Objection, hearsay.
Did he hear
Chesbro,
from
sorry.
Chesbro directly?
Yes. Did he tell you?
Did you want to respond to the objection?
I think it's a proper question. Again, I don't think
What's
that's
his
that important.
evidentiary value though?
Yeah, well, I just think that it goes to, I mean, I don't think this is worth going into so much, but there was a lesson learned from the Gore v. Bush presidential election. That was a very tight election, and things got missed in that election, and Gore gave up a lot of things that, had he not, he might have very well won that election. So there were lessons learned from that informed Mr. Chesbro's decisions on this alternate elector certificate of votes.
Okay, so you're trying to ask questions about that to establish whether or not this witness knew why he did what he did in 2020?
In 2000, yeah, and in 2020, sure, because my assumption is that the lead investigator on the case, who's continuing his investigation even after charges have been filed, is trying to learn things by doing the interviews that he's doing. And so if the witness, Mr. Chesbro, is informing him as to why he drafted an alternate elector certificate of votes, I would think this witness cares about that. And he would evaluate that information and use it to determine what should be done as this case progresses.
So I think the witness can testify, if we're to ask that way, why Mr. Chesbro drafted the document, if he determined that from his conversation with him, why he drafted the document the way he did. But as to your objection to hearsay, you haven't provided me a valid reason to get beyond that hearsay, so the objection is sustained.
Thank you.
Thank you, Your Honor. Okay. Are you aware that Mr. Chesbro drafted various memos explaining how to implement the alternate elector plan?
Yes,
Have you reviewed those memos?
yes.
Did you review those memos before signing your affidavit in July of 2023?
No,
So you reviewed them afterwards?
yes.
All right, I want to walk through those memos, but before I do, anything in those memos that changed your opinions about this case?
I would say that they had an impact on me, like we talked about earlier, when new information or evidence is brought in, it has an impact to go. That makes me understand more clearly where the document, who created the document. So, I was able to determine that.
Okay. All right. I am approaching the witness and handing him what I've marked as proposed defense exhibits F, G, and H. I ask you to take a look at those and see if those are documents that you recall reviewing.
Yes, sir.
Okay. I'm going to take a shot, Your Honor. I move for the admission of defense exhibits F, G, and H at this time.
I object.
Okay, then I'll do it. That's fine. I didn't lay any foundation, so I'll do it. I was just trying to cut this short, Your Honor.
Well, sounds like you were trying the motion to.
Yes, yes. Okay, defense exhibit F. That is a memo prepared by Ken Chesbro to Judge James Trupis dated November 18, 2020, correct?
Yes,
And again, you reviewed this document, right?
yes,
Okay. Do you know who James Trupis is?
yes.
Who is he?
He's an attorney out of Wisconsin, former judge.
Also a alternate Republican elector for the state of Wisconsin? Were you aware of that?
I may have come across that in my investigation, but I don't recall.
Okay. Let's walk through this a little bit and see if the things that are in here caught your attention when you reviewed them after you signed your affidavit. So,
Let me stop you real quick, 'cause something's going on with Zoom. And I can't confirm if this number can see this. It may have timed out. Just because it only gives you, I think, 8 hours. Okay. I don't know. Yeah, just move this out. Andre, can you hear us?
oh, damn.
Just, thank you. She can hear us. Okay.
Come on, I'm not used to doing entertaining.
You can continue. Was there an objection?
Yes, well, one, they haven't been admitted yet, so I'm going to object to, counsel reading from these documents, and they're also hearsay.
Well,
I
here,
thought we were gonna lay some foundation.
Yeah, and here I'm clearly going on the effect on him because he said after he reviewed them, they did impact him, and so I want to explore how.
He did say they did affect him.
But I believe we can just, that question can be asked and answered without eliciting hearsay statements within this document.
Well, look, Your Honor, I think these statements are fair. They were things that this witness either did and certainly should have evaluated as part of his investigation, ongoing investigation. This is about the person who drafted the document that is the basis for the state's charges here. And so to understand what the drafter of the document was contemplating at the time he created the documents is very relevant. And I would imagine has to be very relevant to this witness and should be very relevant to the court in making its bond over decision.
Doesn't make it any less hearsay.
Well, but I think it's important in the witness.
He's not offering for the truth of the matter
Right.
asserted, he's offering for the effect of the listener, which means it comes in.
Well, the effect on the listener does, the document does not.
You said, repeat that?
So, the fact that the witness read the document and the effect that the document had, that comes in as testimony. This does not come in as substantive evidence because it had an effect on the
We've
listener.
not admitted the evidence, he's questioning him about it, I think he's trying to lay a foundation to get it admitted. He's questioning about statements that was in there and how I assumed it affected Agent Shock when he was making the decision. And this is again, a document that purports, to provide information as to what the drafter of this alleged slate was thinking, I suppose. That's, I think, some critical information. The objection's overruled.
Thank you.
Okay. All right, sir. So here, what I'm doing is, so I want to know, not only did each of these memos, whether they impacted you, but I want to know if specific portions of the memos impacted you in the course of your investigation, all right? So what I'd like you to do is I'm going to direct your attention to the second paragraph under summary, first, in the third line.
Yes.
Okay, that's where I was reading.
Okay.
A court decision or perhaps a state legislative determination rendered after December 14th in favor of the Trump-Pence slate should be considered timely. Do you see that?
Yes.
Do you see that this language focuses on something that would happen after the electors voted?
Your Honor, I would ask that that sentence be read from the beginning all the way to the end so that it's not taken out of context. I think the rule of completeness requires that.
Your Honor, the rule of completeness would say, let's get all three of these memos in right now.
That is not what the rule says. It says you read the whole statement. So
This
it's
is
not
the whole
taken out of
statement.
context.
So
Can
let's
you
do
read
it.
can you read the entire paragraph from the beginning to the end?
Just the sentence.
Just
Well-
the sentence
Yes,
for context?
yes.
I'll read the sentence, but my point remains. If we're gonna start citing
How do-
rule of completeness, this
How
document
do
is
we
complete.
just read one sentence out of a paragraph and that gives us context?
Well,
Exactly.
how do we read a portion of a sentence?
How do we read, exactly?
I agree,
Let's get
no, I
it.
agree, we can't read a portion of the sentence, but if you're gonna give me some context, I might need to know what the whole paragraph is talking about. Cause I don't know.
Well, I object to the whole thing, but I know, I'm understanding and
Right,
respecting the court's ruling. If we're going to read portions, it has to be the whole sentence, or it takes the statement out of context.
I completely agree to that, but I also could understand certain sentences read by itself could be read out of context.
That's
And I
fine.
have no clue what this I have no clue what is being read right now.
Right.
And so for the purposes of my, education, I want the entire paragraph.
And I will 100% do that, but Your Honor, may I say something?
Yeah.
I'm here as a defense lawyer trying to provide additional information to the court for purposes of its decision, which is a very critical decision. It's odd to me that the state doesn't want the court to see critical information in this case. Now, I understand there's an evidentiary basis perhaps. However, if we're talking about context and completeness, and again, I don't want to be somebody who's reading sentences out of a memo out of context. I read a memo in a certain way. I pull out certain pieces of it because they resonate with me. Other portions might resonate with you differently. So I am all for this court seeing these three memos in their entirety. I think the memos are critical. I think they're crucial to the court's determination. They go into the contingent nature of this document, which has been part of a defense theme. And I'm not sure why we're keeping it away from the court.
May I respond?
You may.
Your Honor, the court has heard a lot of testimony. there are a lot of exhibits in this case, but the rules of evidence are there for a reason. And they have to apply no matter how important the context of a memo might be. And the rule of completeness is one that is very important because just reading the middle of a sentence to the end changes the scope and the landscape of it.
I agree, that's why I requested him to read the entire paper.
Okay, I will do that. Okay, so, on page 1, it's the third paragraph in the memo. And the second one under summary, it says, assuming the electors pledged to Trump and Pence end up meeting at the Wisconsin, now this is not, it's not, I'm gonna go back, excuse me. Let me read it from start to finish. Assuming the electors pledged to Trump and Pence end up meeting at the Wisconsin Capitol on December 14 to cast their votes, and then send their votes to the President of the Senate in time to be opened on January 6th, a court decision, or perhaps a state legislative determination rendered after, and after is underlined, December 14th in favor of the Trump-Pence slate of electors should be considered timely. On this view, the only real deadline during the next month is the December 14th deadline to cast electoral votes, so that any state judicial proceedings which extend past that date, working toward resolution of who has won Wisconsin's electoral votes, are entirely compatible with federal law, provided that they are completed by January 6th. Did I read that correctly, sir?
Yes.
Okay. So, I did read a portion of it, but does that tell you that what, at least that portion, tell you that what Mr. Chesbro was focused on was some event happening potentially after December 14, 2020 that might have changed the state's, here in Wisconsin, election results?
Yes, in Wisconsin.
Okay. Okay. Well, I was going to read a portion, but I'd like to, I guess, read for completeness. The top of page 2, I was only going to read a little bit, but I'll read the entire paragraph, first paragraph.
You're still on your.
I'm sorry, yes, I'm still reading from
Proposed exhibit F.
proposed exhibit F. Yes, sir. The other date of particular significance is the date that the 10 Wisconsin electors pledged respectively to Trump, Pence, and Biden-Harris must meet in Madison to actually cast their electoral votes if those votes are later to be eligible to be counted in Congress on January 6th.
I don't want you to be any of it.
Okay, I'm gonna stop there then. So, do you see where it says, if those votes are later to be eligible to be counted?
Yes.
Does that sound contingent to you?
No.
It doesn't. If is not a.
Yeah, I'm sorry, I got confused. Yes, if those votes are later to be counted, yes, it does sound contingent. Oh, yes. In Wisconsin.
Right. Well, this memo is written to Judge Trupis, who's in Wisconsin, you testified already, right?
Yes.
I want to read the third paragraph of page 2 of Defense Exhibit F. Prudence dictates that the 10 electors pledged to Trump and Pence meet and cast their votes on December 14th, unless by then the race has been conceded, post-paren. It is highly uncertain, given the language in Article 2 requiring that all electors throughout the United States vote on the same day, whether Congress could validly count electoral votes cast on a later date. Did you see that?
Yes.
So doesn't that tell you that the Constitution of the United States requires a vote of electors on December 14th of 2020?
Yes.
If there's any chance for those to be collected or counted by Congress on January 6th, 2021?
Yes.
And Mr. Chesbro is not just making that up. Again, that's in the Constitution of the United States, right?
Your Honor, I'm gonna object, that's speculation, unless we lay a foundation of how he knows how Mr. Chesbro knew this information.
Well, I think he followed it up with, that's in the Constitution, so,
Well,
if it's in the Constitution, I think it's a question.
Yeah, and
right?
if you don't know, that's fine.
I would,
As to the first part, you can't speculate as to, Mr. Chesbro made something up, but he followed it up with the question is that it's in the Constitution, so
I
that's
was
why I'm
objecting.
allowing it.
Yeah, I was just objecting to the first portion.
You can answer.
The date that the electors have to vote is a constitutional requirement. Are you aware of that?
yes.
And are you aware that this actually occurred in our nation's history? Back in 1857, and I think, I want to know if you know this, the Wisconsin electors in that year, a long time ago, but they voted a day late because of a blizzard.
Snowstorm,
Yeah,
yes.
are you aware of that?
Yes.
And Congress debated for 2 days whether they could count the electoral votes from the state of Wisconsin back in 1857 because it was because they signed and the certificate of votes a day late. Are you aware of that?
Yes.
And they never resolved the question because it didn't really matter for that election. But that date, that shows that this date is of real constitutional and federal law significance, right?
Yes.
All right, the next paragraph, quote, and I'm on page 2, paragraph 4 of the Defense Exhibit F, proposed Exhibit F. It may seem odd that the electors pledged to Trump and Pence might meet and cast their votes on December 14th, even if at that juncture the Trump-Pence ticket is behind in the vote count, and no certificate of election has been issued in favor of Trump and Pence. However, a fair reading of the federal statutes suggests that this is a reasonable course of action. Did I read that correctly?
Yes.
Did that statement impact you?
Yes.
Do you think that what Mr. Chesbro did here in creating an alternate slate for 2020 was a fair reading of the federal statute?
You're asking for my opinion
Yeah.
on what he did is fair?
Yeah.
I don't see it as fair.
Good.
I mean, if that's my opinion.
Sure. And you testified before that this is not easy stuff, right?
Yes.
And people have differing opinions, right?
Yes.
And there are legal scholars on one side of this debate, right?
Yes.
And legal scholars on the other side. Fair?
Yes.
All right, let's look at, that's not it, I'll try. Let's look at proposed defense exhibit G. Proposed defense exhibit G is another later memo from Ken Chesbro to, again, James Troupas dated December 6, 2020, correct?
Yes.
And you reviewed this document?
Yes.
Again, you reviewed it after July of 2023.
Yes.
Do you see in section 1A, and I'll just read the whole thing, all the Trump-Pence electors meet and vote in all 6 contested states and send in the certificates containing their votes in compliance with federal and state statutes on December 14th. Did I read that correctly?
Yes.
Did that impact you?
Yes.
At the bottom of page 2 of the memo, where it's section 2, see that messaging about?
Section 2
Oh,
or
uh,
section C?
Sorry. No, page 2.
Page,
Sorry,
okay,
bottom of page 2.
okay.
Yeah, I mean, okay, I'll read the whole thing. If the Trump campaign ends up deciding to have all of its electors vote on December 14th, even in states in which Trump has not been declared the winner, presumably word of this will leak out prior to December 14th. So perhaps before then, there should be messaging that presents this as a routine measure that is necessary to ensure that in the event the courts or state legislatures were to later conclude that Trump actually won the state, the correct electoral slate can be counted in Congress in January, just as the Democrats did in Hawaii in 1960, which ended up with Hawaii's electoral votes being awarded to Kennedy, even though the litigation was not resolved until after the electors voted. Did I read that correctly?
Yes.
So we see here that Mr. Chesbro is relying on 1960 Hawaii, right?
Yes.
And do you see the words, in the event the courts or the state legislature were later to conclude that Trump actually won the state?
Yes.
Okay.
But our document didn't have contingent language.
Right, we're gonna get to that.
Okay.
But I read that correctly, correct?
Yes.
All right, last one on this one. Bottom of page 4. Kind of goes into the reason for, casting an alternate Republican slate. Let me just orient myself here. All right. Well, actually, I'm going to do a little bit more. Were you aware, did you read this CNN article by Van Jones and Larry Leslie?
You have to be more specific.
It's in the memo.
Oh.
It's in the middle of there. I was gonna go to the bottom.
Okay.
But,
Yes, I see it, what you're saying now.
so you read this.
Larry Lessing, November 4th. Yes. Yes, I did review that.
And I'm asking because, again, if I have to read the whole paragraph, I need the rest of it for context because it starts with given such prior statements, so the prior statements are above, and it talks about the CNN article. That's why I'm trying to ask about this.
Okay.
So, did you read the article?
Yes.
Okay. Are you aware that that article came out the day after the election? November 4th, 2020?
It says right in here that it came out on November 4th.
Okay, there, okay.
Yeah.
Got the date right.
I don't recall the specifics of the article. I remember reviewing the article.
Do you remember that this is, again, it's CNN, it's Van Jones. This is at a time where Pennsylvania was looking like it was gonna go in Trump's favor. Are you aware of that?
I don't recall.
And the article talks about the use of alternate electors by the Democrats. Are you aware of that?
I don't recall.
You don't remember that in the article?
No, that's what I said earlier. I don't recall. I remember reviewing the article. I don't recall the specifics of the article.
Do you remember anything about your investigation, whether it's in this article or otherwise, where there was some brainstorming on the Democratic side about the use of alternate electors?
I don't recall.
Would that influence or in any way cause you to think differently about this case if you knew that the Democratic side was considering the use of alternate electors?
I mean, I could play would-haves, could-haves, and should-haves all day long. I'm focusing on Michigan here and the information that I had in front of me. So I don't recall that information. But as any amount of information that comes into my review, I mean, things like this document that we're reading, yes, it has an impact on me.
Okay. All right, let me read the last paragraph, and again, I needed to do that because it at least puts this into some context. It says, given such prior statements by these and other prominent liberal figures, it would be the height of hypocrisy for Democrats to resist January 6th as the real deadline, or to suggest that Trump and Pence would be doing anything particularly controversial in asking the electors pledged to them to please assemble in their respective states and cast their votes and transmit them to Washington on December 14th so that they might be counted in Congress if their slates are later declared the valid ones by a court and/or state legislature. Did I read that correct?
Yes.
Aren't the words that are used by Mr. Chesbro in this paragraph that I just read, if, so they might later declare to be the valid ones by a court, aren't those very contingent on a future event happening between December 14th, 2020 and January 6th, 2021?
Yes.
All right, last memo. Defense proposed Exhibit H. I'm just going to read the first sentence. I'm sorry, strike that. This is a memo from Ken Chesbro to James R. Trupis dated December 9th, 2020, correct?
Yes.
And the first sentence reads, here's a summary of the requirements under federal law and under the law of the 6 states in controversy concerning what is required for presidential electors to validly cast and transmit their votes. You see that?
Yes.
You see the word validly.
Yes.
Did that impact your investigation?
Yes.
All right, this is a little repetitive, but I think consistency is important in what Mr. Chesbro is writing about this document that he drafted, the certificate of votes, which is.
Yeah. I'm sorry, I'm gonna object, because are we talking about consistency of what Chesbro's saying or the effect on the listener?
The latter.
And we talked about the effect on the listener and not bolstering Chesbro with his own memos.
I don't know if that was actually an objection.
It is an objection, Your Honor.
Your objection is that he's bolstering
He's
Chesbro.
bolstering Chesbro's opinion with his own opinions, and I don't think that is permissible under the rules of evidence. And he's using this witness to basically bolster these memos.
Well, he's asking him whether or not the language in the memos had any effect on him. He's not gotten into how that affected him, but